Perfect. How are you doing?
Good, thank you. How are you?
Yeah, not too bad at all, thank you. Thank you very much for taking the time out. Nice background.
Is my BWL the wrong way around?
Yeah. It still looks good though.
Thanks. I mean, yeah. Still all right.
Perfect. So have you got a presentation for us today?
I have, yeah. I'll share the screen now, but I'm just going to talk a little bit before I go through the slides. But if I share the screen now, then we can check that it's working, can't we?
Yeah, absolutely.
Is that good?
Yeah, that was good.
Excellent. Do you want me to just start, Joshua?
Yeah, absolutely. What we'll do is if I'll basically mute myself, turn my camera off, come back at the last 15 minutes for any questions and things like that. Other than that, the floor is yours.
Super. I just wanted to say, first of all, a huge thank you. Reiterate exactly what anybody else has said to you and Alice for putting on this event and inviting us. It's been fantastic to watch, and it's a clear testament of the speakers, the array of knowledge, true testament to the amount of time and effort you've put in. So thank you. Clearly, you have no kids yet, else you wouldn't have had the time and things like that. But no, it's super. It's been fantastic, really great. And again, thank you so much. Looking at the total, you exceeded the 10,000 on the donations.
Quite a bit over that. I think we'll still be getting some more throughout the day. So it'll be interesting to see where we end up.
Fabulous. It's absolutely brilliant. Well done.
Thank you. Thanks for taking the time.
No problem. So I just want to then introduce myself for those of you that don't know me. My name's Hayley Gilbert. I'm a director and commercial property solicitor at BWL Consulting Limited. You might have just watched Paul do his presentation, which was fantastic. Paul, one of my favourites. He deals predominantly with the construction contracts, whereas I'm a commercial solicitor dealing predominantly with commercial property at BWL. I didn't really want to get into anything too heavy today, but I did want to really discuss with you the work we do for developers and really run through with you today some of the alternatives available to developers when they're looking at acquiring sites. We're regularly asked, what can we do to secure a site? How can we move forward? We're not entirely certain of the viability of the site as yet, or whether we can get planning permission. Is there a way to proceed? And what are the alternatives? So I'm not going to go into every alternative today, it would just take too long. So I've chosen 3 particular routes that you can go down. And I'm also, as we go through, going to discuss a couple of the common misconceptions that we come across as lawyers. But I'll do that as we go through and I'll try and clear up some of those points. So first of all, I'm going to start from, you found a site you're interested in, you've approached the landowner, the potential seller, they're happy to proceed, don't know what basis as yet, but they are looking at selling or they're looking at developing the site. Where do you go from there? What do you do next? Well, the viability and success of a development depends largely on getting satisfactory answers to practical and legal aspects and issues before you even consider proceeding or committing to acquiring the site. Again, there are too many to discuss in this one session, but they might include access questions. Can you get access direct to the public highway? Are there any covenants or restrictions on the site, on the property you're looking at? For example, one of the restrictions, the covenants we see regularly is that only a single dwelling can be built on the property. Are there any rights, any temporary rights, oversailing licenses, cranes, things like that, or permanent rights that you require over the land before you can commence with the development and consider whether it's viable? So while you're assessing these as a developer, while you're assessing the key practical and legal issues surrounding the site, or considering particularly how you want to structure the deal, which I'll discuss later in more detail, you might want to look at trying to ensure that you have exclusivity for this site, that the landowner, now who's been made aware that there's interest in the site, it's a good development opportunity, you've approached him or her, that they're not going to go elsewhere, they're not going to go to a third party while you're assessing the viability of the site. So is there a way that you can prevent this? Is there a way that you can try and stop this from happening while you're assessing the viability? Yes, there is, and this is where the exclusivity agreement comes into play. And you might have heard it being called a lockout agreement, exclusivity agreement. They're interchangeable, they mean the same thing. But before I go into the nuts and bolts of what's usually included in an exclusivity or lockout agreement, firstly wanting to clarify a common misconception regarding exclusivity agreements. I am fairly regularly asked, which agreement should I use to proceed with a development site? Should I use an exclusivity agreement or an option agreement? For me, the two agreements are not an either or agreement, they're not comparable. And the reason for that is, and I'll explain now, is that an exclusivity or a lockout agreement is very much an agreement that's entered into at the outset of a matter, with the firm objective of offering the developer, the buyer, time to progress the transaction. Whether this will be ultimately to purchase outright under an unconditional contract, whether it will be to proceed under taking an option, whether you'll proceed under a conditional contract, it's prior to entering into any of these formal contracts or going forward to deciding on what you're going to do. And it's therefore very much as an outset agreement rather than this is securing the site. Sorry, I've just switched my slide on, didn't mean to do that. It's an exclusivity agreement. It doesn't guarantee a sale. It doesn't oblige either party to enter into an agreement. And this is quite often a mistake people make. It doesn't, in effect, secure the site. It does simply lock out a landowner, a seller, from dealing with, negotiating, sending contract to a third party, an interested third party, while I suppose you get your matters in order while you assess the viability of a site. So at the end of an exclusivity period, and once an exclusivity agreement's ended, either party can walk away. No party's obliged to proceed into that formal contract, whether it be unconditional, conditional, or an option agreement. It doesn't oblige either party to enter into that agreement. It doesn't oblige the landowner to proceed. So now I'll look at the nuts and bolts of exclusivity agreements, and this is where my slides come into play, and look at some of the key terms of an exclusivity agreement or lockout agreement. So we'll look at the next slide. Some of the key terms then of a exclusivity lockout agreement. The duration, it must be clear, and there must be a start date and an end date for the exclusivity period. It's got to be a certain amount of time, depending on which side we're acting for. The seller, the landowner, will want to minimise the length of the exclusivity period, because you are in effect locking them out from dealing with anybody else. Whilst a developer buyer will want as long an exclusivity period as possible. Saying that, it ought to be a reasonable amount of time. It ought to be a reasonable amount of exclusivity that you're given to get your things in order to assess the viability to do what you need to do to enter into that formal contract. Consideration. Because it is an agreement, a contract, there needs to be consideration, and it is usual for a landowner or seller to ask for an exclusivity fee. This is often a non-refundable cash sum paid at the outset on the signing or the entering into the exclusivity agreement. And I say non-refundable, that's what the seller or the landowner will push for. The buyer, the developer, ought to be pushing back on that to say or include a provision in the agreement that the exclusivity fee could be deducted from any deposit payable if they do proceed into the formal and entering into the formal contract. Alternatively, consideration itself doesn't have to be monetary. The consideration that the developer, the buyer, is putting in, if you can negotiate having no exclusivity fee, could be very much their obligation to spend money on solicitors, search fees, or not their obligation, the consideration could be that's what they're spending the money on, that's what they're putting into the deal. However, seller, landowner, understandably, will push for an exclusivity fee. But if it is refundable, if you do proceed, it kind of lightens the blow a little bit. So probably the most important part from a developer buyer's point of view is what are the landlord's obligations under an exclusivity or lockout agreement? What are you locking them out from doing? Well, not to negotiate or allow anybody on his behalf to negotiate the terms of the sale of the land. You don't want to have competing interests. You don't want the landowner to be going elsewhere. The idea of this exclusivity agreement is to give you the time to do the deal, to enter into the formal contract. Not to seek buyers for the land, nor actively market it. To allow the developer, its agents, access to the property for carrying out any surveys, any assessment, any looking at the boundaries, etc. Number of different things. Not to send or allow anyone else to send any documentation relating to the land to anyone other than the developer or its solicitors, and certainly not to make any disposition of the property, not to sell the property, not to grant any leases of the property, maybe not to charge the property in the time that you're looking into matters. So what are the developers or the buyer's obligations? So on the other side of the coin, what are you as a developer saying you will do or won't do? The seller or the landowner will push for the developer, the buyer, to do things as reasonably quickly as possible. So to arrange for any reports to be prepared as soon as possible, environmental reports, surveys, etc. To arrange any finance needed as quickly as possible, and to investigate with the local planning authority, highway authority, etc. The likelihood of obtaining any consents necessary for the proposed development of the site. It's also usual for an exclusivity lockout agreement to include confidential provisions. Mutual confidential clause to say that neither party will discuss the transaction outside of their professional advisors. Termination provisions may include that the agreement can be terminated really if the buyer developer decides that they don't want to proceed, they've changed their mind, simply don't want to go ahead. Give the buyer developer the ability to say, okay, we'll end the agreement, we don't need the exclusivity, or they discover something about the site that's unsatisfactory, it's not going to be feasible, it's not going to be commercially viable, and therefore the exclusivity isn't required anymore. And the next point is that the landowner or developer has breached the agreement. If either party breaches the agreement, or the seller therefore negotiates elsewhere, the developer doesn't abide by any of its obligations, either party then can terminate. So that's very much the exclusivity agreement. I do reiterate again that it is an outset agreement, I would say, something that should be dealt with at the outset while you're getting your matters in order. So next step, having entered into the exclusivity agreement or not, but you've decided you want to proceed, you've assessed the practical issues affecting the potential site, and the question may then be, how should I proceed? What are some of the alternatives? How can I secure this site? So we'll look at, like I say, 3 different options. So the first one I'm going to look at, which doesn't need an awful lot of explanation or any slides, I wouldn't say, is an outright purchase. You found a site, you've got your money, your finances in place, you just want to proceed with purchasing it. You're happy to do so. You want to get to an exchange of contract as soon as possible. You're happy to purchase it. It may have the benefit of a planning permission, therefore you don't need to explore that option. You don't need to explore whether it's going to get planning. The planning permission that it's got may be aligned with your development strategy. Again, you have everything that you feel you need to have a successful development. You want to exchange under an unconditional contract as soon as possible. It's a site. It's a site that's good for you. What I would say, and I would stress time and time again on this, and this is all I'm going to say on the outright purchase, like I said, I don't think there's anything else needs saying on it, is that it is so important to carry out the necessary legal due diligence. And as a solicitor, I'm bound to say that, but it is often misconstrued that if a site has planning and the benefit of planning permission, that the legal that from a legal perspective, the development's permissible as well, because you see that it's got the planning permission, it's got the benefit of the planning permission, the development, it can be developed, that it's considered that the legal aspects have been covered. It's simply not the case. The local planning authority and the planning officers don't look at the legals. They deal with it from the planning perspective. That's their bag. They can grant a planning permission on a site. You can then ask your solicitor to look at the legals, review the title, and a number of different restrictions, covenants, etc. Can be found. So it's really important that you do instruct your solicitor to carry out the legal due diligence before you consider exchanging, before you consider getting to that point, because, like I say, you could find that there are restrictive covenants preventing the development that you're proposing. There could be other restrictions. There could be third-party rights. Third parties having a right of access over the site, a right to park, rights if it's maybe land next to commercial premises, the right to unload, load, a number of different rights that if you were to proceed with the development, you could potentially interfere with or obstruct those rights. And it may be that the site is just actually not commercially or cost effective to be developed, albeit that it does have the planning permission in place. So it is really important to get that legal due diligence carried out. And I just want to also just expand a little bit on that, is particularly important, and because we see more and more properties being sold under auction, that again it's maybe a common misconception that if you purchase a property at auction you can then carry out your legal due diligence, you can look at things afterwards. But it's so important that if you're purchasing or looking at a property at auction, you do your legal due diligence beforehand. Once that hammer's gone down in a traditional auction, that's it. That's equivalent to an exchange of contract, completion date set, and you're committed to that purchase once the hammer goes down. So anything after that, if you buy a property, albeit it's got planning permission, benefit of planning permission, you do your legals afterwards, reviewing the title, necessary searches, raising inquiries, etc. You may discover something that scuppers the development. It doesn't make it cost effective, and at that point you've already committed, you're legally committed to purchasing, and if you don't do so on the completion date that's set, then you potentially lose your deposit, claims damages against you, the contract could be terminated. Again, it's not something I'm going to go into in this session, but it's something to be made aware of. So another option, another alternative is taking an option, a call option. Call options are frequently used by developers to secure a right to buy the land, usually if planning permission is obtained, but it's not bound to exercise the option. So very much an option, a call option, gives the developer quite a lot of leeway of whether to proceed or not. If the developer does decide to proceed and exercise the option, then the landowner is bound to sell to the developer. So, albeit the landowner's bound, if the developer decides to go ahead, the developer does not have to go ahead, can simply walk away. And the third alternative we're going to have a look at in more detail is purchasing via a conditional contract. And again, it's quite often that developers are looking at either or, taking an option or purchasing via a conditional contract, and it very much depends on what you can negotiate with the seller. So if we have a look at greater detail about some of the key elements of call options. So a developer's call option, you're not purchasing outright, you're not sure about the planning on the site. Is it going to be viable? You want to take that time to pursue a planning application to see if this site's going to be right for your development. Taking an option over land does give you that time to pursue a planning application before you have to commit to paying for the land. So going into the next point, the initial outlay is going to be limited to the payment of an option fee. You're not handing over the purchase price. You've got this time to pursue the planning application, see if it's viable on the payment of an option fee when the option is entered into. Now, the option fee, as it says on the slide, is essentially the sum agreed with the landowner as the price for agreeing not to sell the land elsewhere while the developer seeks planning permission. I've put a proviso in there to say, note that the developer is likely, however, to incur significant expenses in making and pursuing the planning application, but the initial outlay itself will be limited to the option fee. I've also just popped another note in there just to say VAT and stamp duty, land tax may be payable on the option fee, and that depends on how much the option fee is. It may be that the landowner is prepared to proceed on the basis of a nominal option fee. So we regularly see option fees of £1 paid, and the reason that £1 is paid rather than just simply leaving it blank is that that's the consideration, and for a valid contract there needs to be some consideration. Other times the option fee maybe tens, hundreds of thousands, depending on the land, depending on the seller. There isn't really an average, there isn't really an option fee standard. It would very much depend on the site. So we touched on this previously on the previous slide, is the developer is not bound to purchase. Should the developer not proceed, decide not to proceed, for example, the planning permission is not forthcoming, it just doesn't seem a viable site, market conditions change for the worst, it's just not going to work out, the developer can walk away from the site. It doesn't need to exercise the option. It just gives a greater degree of control to the developer, the buyer. They can simply walk away, but they do have the security of knowing that if they do proceed and exercise the option, the seller is bound to sell. Option period, again, it needs to be certain of an amount of time and start date, end date, and it should be, from the developer buyer point of view, a reasonable amount of time for them to pursue a planning application negotiate with other authorities, the environment agencies given there as an example, or to deal with other authorities, highway authorities, utility providers, to name but a few. There may be others depending on the site, its location. Again, this is a matter of negotiation between the landowner, the seller, and the developer buyer. Purchase price. This is often one of those areas that gets disputed, particularly if purchase price is based on the market value of the land, percentage of the market value. The agreement, the option agreement, has got to be so specifically drafted to set out the mechanism for how the purchase price is going to be calculated. If it's a fixed sum, obviously much more straightforward, but it's based on the market value. It must be drafted in such a way that those mechanisms are set out to see how the value is going to be calculated. I would often say, depending on the market conditions, that for a developer buyer, a fixed sum is often more favourable. Not only for budgeting, but you know, if the market value increases tenfold, you've agreed on a fixed sum. Obviously, the downside of that is that if the market conditions change so adversely that the market value goes down, you've agreed a fixed sum, you're in a worse position. And again, it's a matter of negotiation between the seller and the buyer. When we talked about the option period being a set amount of time, the developer buyer should ensure that the option agreement does provide that the option period can be extended in certain circumstances. And I've given some examples there, but there might be a number of other different circumstances. The first one being the application's been made, so you've submitted as a developer buyer, you've submitted the planning application, but the local authority hasn't yet given its decision. So the option period for an example is 12 months. You come into the 12-month period, you don't, as a developer buyer, want that option agreement to end at the 12-month period if you spent the money, you submitted the application, you put it in the local authority, there simply hasn't been a decision made. So you want a clause within the agreement to ensure that the option period can be extended in that circumstances. And again, if the planning permission's been granted, but the period for possible third-party challenges or judicial review has yet to expire, you don't want to come to the end of the option period, have the planning permission granted, but have a chance that somebody may challenge that. So you want to provide that there's going to be an extension if that's the case. Another couple of examples: if the planning permission is being granted but the developer wants to appeal against an onerous condition on there, or the planning permission is being refused but the developer would like to appeal the decision, you want to have a clause in there to make sure that it can be extended in those circumstances. Now, for the seller, that amount of extension is they're going to want to make sure that the option agreement can't continue indefinitely. They've got to say, okay, we want to say there's a long stop date. There's a date at which point we say, okay, enough's enough. You haven't achieved the planning permission, you haven't bought the property, proceeded, exercised the option. This date is the end date, so it can't extend indefinitely, and that even if some of those circumstances mentioned before haven't been met and the timescales, it can't just keep going on and being extended. There's a final cut-off date, and what that date is, how long it is, again, is a matter of negotiation. The final point on this slide is registration of the option. So in order to bind a successory in title of the landowner, so if the landowner does go on to sell, for example, the option agreement should be noted, protected by the registration of a notice on the title. So a notice on the title to show any third party coming that this option agreement is in place. If anybody wants to purchase from the seller, that they have to abide by the terms of the option. It just puts people on notice that there's option agreement in place and protects the developer buyer's position, that the seller can't, you know, dispose of the property without people being aware of it and people taking the property free from the option agreement. So it's imperative that it is registered as a notice on the title, on the seller's title. So that's very much in a nutshell, call option, developer's call option, conditional based on planning. So now what I'm going to have a look at some of the key terms is of conditional contracts. So the main difference between the conditional contract and the option, the call option, developer's call option, is that, as I mentioned, in a call option, the developer has the right to walk away from the deal. Even if the planning permission's obtained and for whatever reason they don't want to proceed, the developer doesn't have to exercise the option. The developer can walk away and not proceed. With a conditional contract, it's a little bit different because it's very much if the condition that's included in the contract is satisfied, the developer is bound to purchase. So it's very much exchange. A conditional contract is, okay, we've exchanged, everybody's committed to the purchase, the sale. However, it is dependent on a condition being satisfied. And one of the most common conditions, and the one that we'll talk about throughout these slides, is that planning permission is obtained prior to completion. So that must be satisfied before the purchase completes. Just mentioned there that the developer is bound to complete if the conditions are satisfied before any contractual long stop date in the contract. The purchase price, understandably, is usually based on the assumption that the property has the benefit of the planning permission being applied for. So, as it is a condition that planning permission is obtained before completion, it makes sense that the purchase price would reflect that the purchase price is based on the land having the benefit of that planning permission. The next point I've put is satisfactory planning permission, and this is to say that the developer buyer should ensure that the contract is clear on what considers to be a suitable or satisfactory planning permission, and satisfactory to the buyer. So the contract may provide that satisfactory planning permission is one that doesn't contain an unreasonable or onerous condition. So the definition of unreasonable condition or onerous condition in the contract can be very, 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 very wide for the developer buyer benefit. So the wider the list of those conditions that the developer or buyer would consider unreasonable, the more discretion the buyer developer has to reject a planning permission and walk away from the deal. On the flip side, the seller landowner is going to want to make that as a narrow, as a smaller list as possible, so that the list of conditions to enable the developer buyer to walk away are much more limited. And again, this would be a matter of negotiation and to and froing, usually between solicitors. But we would say, acting for developer buyer, that to include as many conditions that could be considered onerous or unreasonable as possible, which could include that it's not economical or financially viable for the buyer or developer to proceed for one of the conditions. It will generally pushed back by the seller, but we would recommend that would be included. So buyer obligations, what are the buyer developer saying that they'll do in the contract? Conditional contracts usually provide that the buyer will use reasonable endeavours to obtain a satisfactory planning permission before any long stop date. Long stop date being, as previously discussed, the date that the seller says, that's it, that's the cut-off date. So by saying that the buyer or the developer will use reasonable endeavours to obtain a satisfactory planning permission as soon as possible, gives the landowner or the seller some assurance that the buyer won't drag its heels to delay completion. Other obligations, other things that are likely to be included or should be addressed within a conditional contract, is from the seller's point of view, really, the period in which the buyer must lodge the planning application. And I've just put as a note in there, albeit I mentioned reasonable endeavours to proceed with the planning application, there may be a provision which sets out the timescale to abide by. And this simply ensures or assures the seller, gives them some comfort that the buyer developer isn't dragging their heels. Another provision that could be included in the contract is whether the landowner or the seller has a right to approve the form of planning application before the buyer is able to submit. So quite often the landowner, the seller, wants to make sure that they can approve any planning application, beg your pardon, before the buyer submits it to the local authority. They want to have a say in it. They want to keep a degree of control over what can or cannot be done on the site. Other situations, the landowner seller simply wants to wash their hands very much of the site, doesn't want any involvement, leaves it to the buyer developer to deal with, and doesn't want to approve. Again, it's a matter of negotiation, and quite often a matter of if the developer buyer and the seller are closer, have a relationship beforehand, know each other, and the seller landowner knows the developer, trusts the developer, they'll may be less likely to want to have to approve it. But again, a matter of negotiation. Another provision, whether the buyer should be obliged to appeal in the event of a planning refusal. It's often pushed for by sellers, landowners to include a provision to say that if the planning application is refused, planning permission is refused, that the buyer will appeal. Obviously, it's more benefit to the seller because they'll, they want to sell this land. They want to get to the point of being able to complete. Buyers likely to want the freedom to decide whether or not to appeal. It's likely to push back on a provision, insisting that they do appeal if it's refused. There's a middle ground, maybe a compromise, and often conditional contracts are drafted on the basis that the buyer does have to appeal or is obliged to appeal. However, if the costs of doing so reach a certain threshold or go over a certain amount, then they don't have to go any further, and maybe that's a compromise, a bit of a middle ground. Obligations I've just included here is an obligation on both parties to cooperate with each other, keep each other informed. Again, it goes back to the previous point, whether the seller, the landowner, wants any involvement in it or not, but it's quite often that there's this mutual agreement to cooperate and keep each other informed. This is a particularly important one when you're acting for the buyer developer, is the restrictions on the landowner from applying for planning permission itself in relation to the property. You obviously don't want a complete planning permission being submitted by the seller. Extensions, going back again to pretty much the same as what we went through with the option. A buyer should insist on the contract providing that the completion date is not on the granting, the issuing of the planning permission itself, so that the planning permission is granted, been issued, completion happens. You've still got that element of risk that the challenge period hasn't expired. You complete on a matter, and then the third party challenges the planning permission, with the worst case scenario that it's overturned, it's repealed. So we would suggest from a buyer developer point of view that the contract instead provides that completion only happens once any period for challenge has expired, and therefore trying to alleviate the risk. Termination provisions. Again, it differs quite a lot of termination provisions, but the agreement should specify a long stop date so that the contract can be brought to an end if no progress is being made in terms of satisfying the condition. So if the buyer developer hasn't done anything to proceed with the planning application, it could be terminated. The contract may provide that it terminates automatically upon the occurrence of the long stop date, or it may continue after that date until a party serves notice to terminate. So it's either or. Straight away it would terminate if the long stop date occurs, or it may be drafted to say that it will continue until a party serves notice to terminate, and they may be able to serve notice to terminate once the long stop date's occurred. Again, it's a drafting negotiation point. But if notice is required to terminate the contract after the long stop date, the relevant clause should make it clear that the contract may only be determined at that stage if the condition has not been satisfied. So a buyer who has obtained satisfactory planning permission after the long stop date won't want the seller to be able to terminate the contract simply because the long stop date's occurred. Again, for those are the reasons that we mentioned previously. Before I open it up to any questions, there was another possibility, another avenue that I did look at discussing, but maybe it's one for another time, is that the use of a promotion agreement. It's another agreement that people want to talk about, and it may be useful in any situation as a way to develop without having the finance in place to purchase the land, which may be more relevant in the current climate. And a promotion agreement, very much in a nutshell, is that the developer must use reasonable endeavours usually to secure planning permission, but it doesn't buy the land once the planning permission is granted. Instead, it markets the property, secures a sale, and once the sale's completed, it shares proceeds with the landowner, usually after deducting the cost of obtaining the planning permission. And again, like I say, this can be useful when funding's scarce. Downsides of promotion agreements, other than the obligation to try and secure the planning permission, is that the only security the developer has, they have no interest in the land. It's contractual security, and obviously it's given part of the profit away at the end of the development. So that is really where I come to an end of the presentation. And like I say, open to any questions.
Perfect. Yeah, so we've got quite a few questions come in from that. First of all, thank you very much for the presentation. Hugely informative, and really kind of covered quite a lot there in a short amount of time. So what's the first question we've got? What is deemed a reasonable time for the lockout for both parties?
It's a real difficult one to answer, because it very much depends on the seller, the landowner. It'll very much depend on what it is that you're trying to sort out, and that really is dependent on the location of the site. And it really, Joshua, it's impossible to say. It's 12 months is often a time scale given, but that's just the number that I've taken out of my head, that we've put on exclusivity agreements a few times, but it does really differ so much depending on the site and depending on the landowner and what can be negotiated.
Yeah, absolutely. Perfect answer.
It was a
Josh,
typical
what's got?
solicitor's answer, wasn't it? Very, very political.
Well, it
Answer.
depends. That's my favourite answer. So with exclusivity agreements, do you put any restrictions on title?
No, because you're not getting an interest in the land. It's purely contractual. It's very much you're not getting an interest in the land. You're just obliging or asking the landowner not to deal with any third parties. You're locked out from doing so.
Perfect. So we've got one more here. So if the with an exclusivity agreement, if the landowner breaches, what compensation would you be entitled to?
It would be a breach of contract. It's purely contractual. Breach of contract. Damages you may include in an exclusivity agreement the loss of opportunity, and again we would recommend that was included. The seller may not agree to that, and honestly, if we were acting for the seller, we may say that wasn't, we wouldn't recommend that they agreed to that, but contractual damages you could include loss of opportunity, loss of profit, and then that could extend to however much you were expecting to get from developing the site. But at a lost opportunity is mainly where the compensation would come in, damages.
Yeah, perfect. When doing an option subject to planning, is it more common to purchase at value with planning, without planning, or with planning?
Sorry, can you repeat that?
Yeah. 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 Okay, yeah. So when you purchase, when you've got an option in place, which value do you apply? So when there's an uplift, so essentially when you get planning, the land increases in value. So which value do you purchase it? Is it the date when you strike, when the option is created, or when it's exercised?
Depends whether you've agreed on a fixed price, because if you agree at a fixed price at the outset, that's the fixed price. It doesn't matter. If you're basing it on market value, it's again a matter of how the contract, the option's drafted, as to whether the planning uplift is taken into account or whether it's not. And if it's the seller, they'll obviously want the uplift taken into account on the market value. And it's a real good question and something to discuss with your surveyor, which is always something we recommend when you're taking an option, is to discuss all the market value provisions. If you are doing it on market value, any percentage deductions, etc., is something really to discuss in great detail with a surveyor.
Perfect. So what else do we have? Got time for a few more questions here. What type of developments do you see large option fees payable, and are these normally negotiated to be knocked off the eventual purchase price?
Again, it very much depends, but and it again depends on whether we'll do it on the basis we're acting for developer buyer. Then yes, if the seller landowner agrees to it, then you may deduct the option fee from the purchase price, and in doing so, it helps if you're paying a large option fee. For example, I mentioned that SDLT, stamp duty, is payable potentially on an option fee. If you can negotiate that option fee is deducted from the purchase price, you're obviously looking at a less SDLT liability, because it's not forming, you've not paid that as well. So from a buyer developer's perspective, you would insist, or you would hope to be able to deduct the option fee, but because the seller is very much, he's prevented from, it's a bit of a stalemate situation. He's prevented from dealing with the land. If you've got call options to buy a developer, and you do have that control of whether to exercise it or not, and you might not proceed, you might never go ahead with the purchase, the seller's going to want to have something, you know, if you don't proceed. So if you proceed, it is knocked off. If you don't proceed, then it's non-refundable. Maybe that again the middle ground, the compromise, because you're not going to want to be a seller or a landowner granting an option for very little fee to get potentially nothing out of it at the end of the day if the developer buyer walks away and never exercises the option.
Yeah, absolutely. Someone's asked if you could quickly run through promotion agreements again, perhaps in a little bit more detail.
A promotion agreement is you're not getting an interest in the land here. It's very much your giving the example, Josh, you are the landowner. I'm going to come along and say, look, I've got the expertise as a developer of knowing what to do with submitting the planning application and getting the planning permission. You're going to put the land into the deal. I'll obtain the planning permission. Again, there may be a promotion fee for doing so because the landowner's saying that they're not going to deal with the land while the promotion agreement's in place. But I'll get the planning permission. I'll deal with the land. I'll get the planning permission. I'll promote it. I'll market the land. Either I'll do it myself or we'll do it jointly, the landowner. We'll market it, sell it. Obviously, you retain the land. My name's not on the title deed, so when we do come to sell it, I've got the planning permission. May not have developed it, may have just got the planning permission, may have developed the infrastructure, what have you, but selling it with the benefit of a planning permission, so there will be that uplift. Sell it, I deduct my costs from submitting the planning application and everything needed to get the planning permission, and then the profits are split. So you get, say, 50-50, we do a 50-50 basis. I'm never getting an interest in the land. I'm simply promoting the land. I'm simply getting the planning permission. We market it, sell it, and the agreement is then we split the profits. It's still, you know, once it's to sell it, you have to, as the landowner, have to sign all the agreements. You're selling it, you have to do all of the signing at the solicitors. It's still your land. I'm just very much doing I suppose a joint venture with you that I'm putting my expertise in to get the planning permission, doing all the drawings, getting it to a point that we can sell it with the benefit of the planning permission, and then split any uplift, split any profit.
Perfect. Yeah, hopefully that helps you out there. So what else do we have? What about planning objection costs, appeal, other conditions costs that affect your due diligence on purchase viability? Rashmi, could you just give a little more context about what that's about? I think. So if a landowner breaches, okay, I'll just scroll up a bit. Yes, if a landowner breaches the agreement, does he pay your costs? And also, what about the costs in obtaining planning and other such costs?
Is there a breach of the option agreement, we say? Yeah.
Yeah.
Yeah, it would be very much a breach of contract claim, and as any kind of contract and a breach of contract, it would presumably go to court, and then it would be decided on what damages would be payable, what the judge decided of what would be payable, and it wouldn't seem unreasonable to include money spent on the planning, any appeals, etc., because that was done on the basis that the landowner developer could then exercise that option and proceed to purchase. And if the landowner has breached the option agreement, that they're in breach of contract, and damages should be payable to compensate the non-breaching party. So it's very much on the principles of breach of contract and damages payable for the breach of contract, put them in a position that there would have been if there had been no breach.
Yeah, thank you very much. Yeah, got time for a couple more still. So Alex here, in what case would you use a lockout agreement instead of an option agreement from the start? Seller could take your planning application and sell it to another developer, !
If you have decided that's the way forward, you're going to take an option of the land, you're going to enter into the option agreement, then potentially there's no exclusivity agreement needed. As long as you can get to the point of negotiating the option agreement, you've come to a final decision, and that is the option agreement is in place. That's your formal agreement, that's your way forward, that's your interest in the land. The exclusivity agreement would sit before that, in my eyes, whilst you're going to and fro from solicitors about the option agreement. Are we agreeing this point in it? Are we agreeing this clause in it? Are we agreeing this, that, and the other, to finally reach the formal agreement, the option agreement? The exclusivity agreement's in place to lock the seller out from dealing with anybody in the meantime, while you get into the point of, you know, signing the option agreement, getting that interest in land, and entering into that formal contract. For me, they're not really comparable. But if you've got the heads of terms for an option agreement, and there's going to be no to and fro in between solicitors, for example, you have an option agreement and you're not taking any legal advice, which I always think is a crazy idea in itself. But if you want to do that and enter into it, then, you know, and all terms are agreed, you potentially don't need the exclusivity agreement. But it's that interim between getting to that point of an option agreement that's in its agreed form, entering into that, where you're both bound in the sense that you're bound contractually to do what you're saying you're doing in the option agreement, then potentially you don't need the exclusivity agreement. But it's for that point in time before you get to that you don't want the landowner saying, actually, I'm not going to go ahead, I'm going to go ahead and sell to somebody else, or I'm going to get to enter into an option with somebody else.
Very well answered, thank you. Yes, we've still got a little bit of time for a couple more questions. So what are the dangers of using your own agreements or kind of template ones and writing up your own kind of lockout and exclusivity agreements?
In a nutshell, it's the same as me having no experience in valuing a property, going along to a site and saying, I'm going to pay £6 million for that site, that's how much I value it, or I'm the landowner, that's how much I'm valuing it, or I'm a developer, I'll go along, actually it's worth £3.50. The relevance of me doing that as a valuer is negotiable. It's irrelevant, isn't it? I could say any price. And the same as a solicitor, from my point of view, is that's what we do. We look at the legal agreements, we look at the ins and outs of it, we look at what could go wrong. More often in every single scenario, it drives you bonkers of what could go wrong, the worst case scenario. Why wouldn't you put an agreement in place? Why wouldn't you have it set out? Why wouldn't you have it looked at by somebody who's been, who's legally qualified, who can say what the risks are? It's a no-brainer for me, obviously, from my point of view.
Yeah, absolutely. I certainly agree with that one. Just kind of extending on that a bit further. So, what's the kind of biggest, mess up you've seen, or kind of from an expensive or legal point, of somebody using their own lockout agreement that's been poorly drafted, and has basically messed them up from a kind of legal standpoint?
If you have a lockout agreement and I think that the main point about a lockout agreement is it's a lockout agreement and not a lock-in agreement. And many people make the mistake of thinking or drafting it or creating it themselves to oblige a landowner to enter into an agreement at the end of the exclusivity period. And the problem with that is that it would be classed as an agreement to agree and be void for lack of certainty in many cases. Because if you don't have the form of agreement attached to that exclusivity agreement, for example, and saying this is what we're going to enter into at the end of it, and we've agreed and negotiated it, which would absolutely negate any reason to have an exclusivity agreement, you're actually saying to one of the parties, okay, you're agreeing to enter into something that we don't know what it is, we haven't agreed the terms, and therefore in law they're saying it's an agreement to agree, which is not a valid agreement. And that's probably the most common common example of somebody doing that is actually they've tried to tie somebody into agreeing to something in the future where no terms have been agreed, where nothing's firm, and then therefore if there's any discrepancies, the court would just say it's an invalid contract and it's void for uncertainty, and that's a big mistake that you can avoid by drafting it correctly.
Yeah, absolutely. So that's that. Your presentation's been invaluable. Everyone's really enjoyed it. Everyone's Craig here. It's been super helpful. Thank you very much. Some fantastic feedback. So first of all, thank you for taking the time to do this presentation. It's been super helpful. And that's all we've got time for today. But thank you very much, Hayley. It's been a pleasure.
Thank you very much. Thanks for having me. It's been great.
Perfect. Enjoy the rest of your day. We shall speak soon.
Take care. Bye.
Bye.